Hi everybody and welcome back. This week is going to be our first week in discussing special populations of among incarcerated individuals. And first up, what we're going to do is talk about juvenile offenders. And as we've sort of discussed briefly before, juvenile offenders are very different from adults, from the way they commit their crimes to the crimes that they actually commit. So what we're going to do today is focus a little bit on the idea of their developmental stage. And in talking about that, really, if you think about the way that juveniles develop before adulthood, it's fast, it's rapid, it's ever-changing, and our brains are not fully developed until the age of 25, right? So the younger that we are, the more likely it is that we're going to act on impulse, that we're going to have control issues possibly. There's different cognitive factors at play with juveniles compared to adults, and really when we're talking about young children, 7, 8, 9, 10 years old, you sometimes hear stories about, children are shooting other children, or they get a gun and they shoot their parents or something like that, and it's more likely to be an accident than actually something malicious or intended for that to happen. And really that's because the younger we are, the less likely it is that we're able to actually legally form mens rea, or the criminal intent to commit an act. So in this lecture today, what we're going to do is look at things from a little bit of a historical perspective and talk about the development of the juvenile justice system, and then we're going to make our way into the more modern applications of the juvenile justice system compared to sending juveniles to adult courts. So we know that historically juveniles have not always been treated differently than adults. 100, 200 years ago, juveniles were more frequently being sent to adult prisons, being processed through the adult system, and it's really not until 1899 that we see the first formation of the juvenile justice system, and that was developed specifically as a way for the United States to deal with the prosecution of juvenile delinquents. The juvenile justice system was formed, like I said, in 1899 in Cook County, Illinois. That's the Chicagoland area, and that was done as a way to process juveniles differently from adults, because even in 1899 people are realizing that young children, minors, are vastly different in a lot of different areas than adults. So we're seeing this sort of clear divide in reference to how juveniles need to be treated within the system and how they are often more vulnerable than adult offenders. So when we're talking about the concept of juvenile delinquency as a whole, remember that we're really focusing on juveniles that are between the ages of 7 to 18. 7 is often the cutoff because that's when more cognitive development really takes off. So we're talking about 7 being the age of more significant cognizant development. However, we're still not at the age in which these juveniles, really children at 7, they're too young to really form intent, but there is still the cognizance to be able to say, well, this was right, this was wrong, and that formation is still developing. However, if you think about maybe your own children, the idea that stealing is wrong, or lying is wrong, or doing this is the right thing, bullying other children is wrong, pushing children down on the playground. So this idea of right versus wrong is already developing, but not in the legal cognitive sense quite yet. So starting from a rather young age, going all the way through to the age of adulthood. So when we're talking about the juvenile justice system being developed, we have to discuss the Juvenile Court Act. And this was the thing that first gave Chicago the ability to have a rather broad jurisdiction over people who were under the age of 16 at the time. The definition of what was considered an adult has evolved over time, but anybody who was under the age of 16 who was either delinquent, who was facing neglect or potential abuse at home, or who was a dependent of the state. So all of those children would be wrapped up under this act. And what that basically meant was that the state was given authorization to essentially step in and be the juvenile's parent. So we first see the development of the concept of parens patriae, in which the state becomes your parent. So as a juvenile, I'm not able to enter a legally binding contract, and I cannot represent myself, so the state will step in and serve as serve as the adult that will do all of these things for me. So they will step in and serve as my pseudo-parent, if you will. So under this act, it forms the original juvenile justice system, and it allows for special judges to have specific hearings that are geared toward juvenile offenders or just juveniles who are not considered delinquent at the time. It's being held in a separate courtroom. Adults are not involved, like there's no other adult offenders in the room. And then there is a separate record keeping of everything that takes place in that in these juvenile hearings. So you're seeing the first instances of separation from adult offenders and the adult system. So, but the problem with this is that once you create this separate sphere in which juveniles are being processed, they're being treated by adults, or they're being treated differently than adults. So the question then becomes, are they still afforded the same constitutional rights when we're talking about things like due process and the right against self-incrimination, all of that, because they're not considered legal adults yet. So do all of these things still apply? So as we're talking about that question, we're still developing the answers to these questions, but the juvenile justice system is really taking off, and we're seeing a lot of other states and a lot of other areas sort of adapting the Illinois model, if you will, or what is coming out of the Chicago area, because at the time it seems to be working quite well. So even when juveniles are being challenged, or juvenile courts rather, are being challenged legally, everything that these courts seem to be doing these efforts are generally upheld by SCOTUS, because they keep invoking this principle of parens patriae, and by doing so, I guess, what am I trying to say? By invoking that principle, they're acting on the behalf or the best interest of the child. So a lot of the things that they're getting are going through because it's both supporting the child's best interest and the state's efforts to try and curtail juvenile delinquency at the time. So even though there are some basic legal challenges at the time, there aren't much. And the state itself really is not taking a vested interest in a lot of oversight or regulation of the juvenile courts. So basically what's being allowed is that for juvenile courts and the people who have a vested interest in them, they're allowed to sort of have this free-for-all, if you will, in trying to push their own agendas. And this really shows itself by the lack of transparency that is taking place within these court hearings, because if you remember from a few minutes ago, they had separate hearings in separate rooms that were not open to the public. So by closing them off to the public, you have a strong lack of transparency. In the adult court, if I wanted to right now, I could walk down to the courthouse, go in and sit in on a trial, sit in on pretty much anything I wanted to do. They're open to the general public. In high-profile cases, they might limit the amount of people that come in, but if it's just some random guy, I could walk in right now and sit and listen to his trial if I wanted to, because they're open to the public. And at the time, this was not true for juvenile courts. So this lack of transparency and a lack of consistency in terms of sentencing from the judges and other court officials, minors who would come into the room sort of had no idea what to expect, depending on the judge, depending on the temperament he was in. It was sort of a crapshoot in terms of what you would actually be getting. So as the juvenile justice system sort of develops, we see more legal challenges, especially in the 1960s. It becomes the decade of the legal challenge for juvenile court systems. So cases that are coming up before SCOTUS are really trying to attempt to retain legal rights and constitutional rights for juveniles who are within the juvenile justice system. So for instance, one of the first landmark cases we ever here at the court level, or Supreme Court level rather, is Kent v. United States that takes place in 1966. So in this instance, we have a juvenile named Morris Kent who is being charged as an adult for robbery and rape. And it was there was no hearing. It was just an automatic waiver to the adult court. So there was nothing that took place that allowed for any sort of review of his case. It was just an automatic shoot him up kind of thing, send him straight to the adult court. So in the appeals process, SCOTUS came back and ruled, and they said, well, you just can't send them there. You can't just have this automatic waiver for anything and everything. You have to start having hearings, and you have to start having reviews of each individual juvenile case. So the idea of due process is being brought into the juvenile justice system. Juvenile court justices can't just simply waive you to the adult court without some sort of due process being put in place. So we see the very first landmark case that's extending adult due process rights to juvenile offenders. So at the very least now, you need to have a hearing before the transfer could occur. And there has to be then a strong and very sufficient reason for the transfer, right? So if let's say I stole from a Walmart, right? Petty theft, I steal something that's not even worth $50. This might not even be something that really runs itself through the entire system. But let's say that for some reason I am charged. In the waiver hearing, you could not say, well, $50 is a strong and sufficient reason for why I should be sent to the adult court. That's not a case that would be transferred. However, if I am 16 years old and I murder my entire family in their sleep, that might be a reason for me to be waived to the adult court, but I still get my hearing before the automatic transfer. Excuse me, a year later, the Supreme Court hears a secondary landmark case, which is called In Re Galt. That happens in 1967, and this again extends the due process protections that are afforded for juvenile offenders who remain in the juvenile justice system. Excuse me, and this case basically extends the protections facing self-incrimination, the right to be notified of the charges that are being levied against you, the right to confront and cross-examine any of your accusers, the right to assistance of counsel. So having an attorney is now something that is afforded to you, and then the right to sworn testimony and appeal. So In Re Galt really covers a whole bunch of different things. And later cases further extend this and go into more detail about these rulings. But we have some of these landmark decisions that are really laying the groundwork for suitable protections for juvenile offenders. One of the things that is different about the juvenile system is that when juveniles are processed, they're never found guilty. They are adjudicated delinquent, but they are never found guilty like adults are. So if they're not being found guilty in terms of using that terminology, the assumption then was that the prosecutor did not need to find or prove them guilty beyond a reasonable doubt, right? So In Re Winship comes along and SCOTUS rules, and they said, well, I mean, even though you're calling it something different, it is an adjudication of guilt. You're just calling it something different, and nothing really changes, especially if when you are adjudicated delinquent, you have the possibility of facing incarceration or detention sentences. So again, because there is this potential loss of liberty, you need to prove them delinquent beyond a reasonable doubt. Excuse me. So the same standard needs to be there even though you're calling it by something different. So anytime there is a potential loss of liberty, a proof beyond a reasonable doubt standard needs to come in. A couple years later, in 1971, we see another case, McKeever v. Pennsylvania, pop up, and it rules that juveniles are not necessarily entitled to a trial by jury, and this decision was really sort of trying to solidify the idea that the juvenile court system is different than the adult court system, and that the juvenile court system is really founded on the principles of rehabilitation and treatment. So if you have a jury of your peers And if I'm a juvenile, my peers would be other juveniles. This doesn't really work out the same way that it would at the adult level. So this case really takes the idea of a trial by jury away and puts the sole decision-making power within the hands of the judge itself. So instead of having a group of juveniles who are also unable to make legal decisions, and you can imagine that if you have a bunch of 15, 16-year-olds there, they might not be the best judge of character. They might not take this as seriously as you hoped. There's a number of reasons why you don't want a jury pool of 16-year-olds. But everything is going to go back to the judge, right? And we still have, it's a formalized process in which the judge is ruling over everything, but it's really sort of speaking to an informalized process as well. So you wouldn't find that necessarily acceptable at the adult level. So it's a little bit more informal at the juvenile level, because there's not as much at stake comparative to some of the adult sentences that you would see being handed down. And again, like I said, the focus is really on rehabilitation. The focus is really on trying to treat juveniles so that they don't become perpetual adult offenders. So I know that this is just a couple of the little things that touch on the juvenile system, and there are tons more of constitutional rulings that SCOTUS has handed down, particularly in terms of the death penalty, life with parole, life without parole in more recent years. But instead of going through every single ruling that the court has levied or has ruled on, I really want to take a few more minutes and talk about the importance of why these constitutional safeguards are being ruled upon. Because the majority of juvenile offenders will not be transferred to the adult court. They're going to stay in the juvenile system. They're most likely not even going to be institutionalized or be sent to any sort of detention centers. They're more likely to receive things like diversion or juvenile probation or some other community-based sentence that is meant to keep juveniles out of the system, the criminal justice system, in the long term. And again, this idea or this reasoning sort of goes back and ties into the idea that the juvenile justice system is different, and it's meant to be different, and we're trying to keep it as different as we can. We're all about treatment, reform, rehabilitation, rather than punishment like we do with adults. The juvenile justice system was originally meant to identify differences between youthful and adult offenders, to separate those differences out and to treat the special characteristics of youth, right? We're meant to rehabilitate juvenile offenders so that they desist in their offending patterns and they don't turn into adult offenders. And we know that if juveniles are not rehabilitated and they're not provided the adequate services that they need to be rehabilitated, to get them back on track, to provide the help and services that they need, then there is an increased likelihood that they're going to turn into career offenders. And once they become a career or a life course persistent offender, we know that they are bound to keep reoffending in the long term, and that's something that we really want to avoid. Because the revolving door aspects of the criminal justice system really are just creating a plethora of problems, if you will, for offenders who are trying to successfully reenter society. We know that it's hard to find housing, it's hard to find a job, it's hard to maintain social ties, and all of these things are sort of embedded within this umbrella term of social capital. And we know that as social capital decreases, the likelihood of offending goes way up. And social capital, you can really think about this more in terms of like community collateral, right? So the friendships I have, the relationships that I have with family members and loved ones, access to basic health care, opportunities for employment, access to resources, being able to just go see my probation or my parole officer, having adequate transportation. All of these things really are built up under this umbrella term of social capital. So when social capital rises, think about this from an economics perspective, right? So when my social capital rises, I'm invested in a lot more. I have more at stake, more to lose, so I'm less likely to be committing additional crimes because I don't want to lose all of that. I don't want to put my collateral at risk. So when juveniles are remaining in the community and they're not being detained in a detention center, or they're not being sent to the adult court and to adult prisons, they're remaining in the community. They're more likely to retain those ties. They're more likely to keep investing in the social capital that they already have, and subsequently they're ending their offending patterns. And that's really what we want. We want to see that desistance in offending, and we want them to not continue and be perpetual in nature. But one of the things that, as we're talking about these community-based efforts, especially as it ties into the age of the offender, we see a bunch of states that are now moving towards this effort of raising the age for juvenile age of maturity in the systems. And this movement is ironically enough called Raise the Age. And Raise the Age states are really advocating against the transfer of juveniles to the adult system for certain specific crimes, and they're trying to raise the age of juvenile jurisdiction to 18, 19, and in some cases 20 years old. And Connecticut was one of the very first states to be able to do this, and they are a strong success story. So if you're interested in this effort, I encourage you to go learn a little bit more about what Connecticut's doing. But Connecticut was one of the very first states to raise the age to 18. So even if you commit a specific crime at the age of 18, you're still going to be funneled into the juvenile justice system, even though you are technically a legal adult. If one of you, whatever you do is eligible, you'll be funneled into the juvenile justice system rather than to the adult court system automatically. So they successfully raised the age to 18, and they're currently, at least at the time of this recording, they're on their way to pushing the age to 19. So we'll see if they can do that for specific crimes or all crimes across the board. But this was so successful that after Connecticut was able to raise the age to 18, they saw a significant drop in the amount of juvenile crimes that were being committed, almost like way more so to the point where they actually have 3 institutions or juvenile justice detention centers in their state, and they were able to close one because the crime rate dropped so drastically. And that might not be a good thing for the prison industry, but that is a wonderful thing if you're thinking about it in terms of reform and what the correctional system as a whole is trying to do. So there are some problems with it, and Connecticut understands, if you're closing down these facilities, what do you do with these other juveniles? Overcrowding them potentially becomes an issue, or you have to start detouring these individuals to other different sites or facilities or what may have you. So it's not a perfect process, but they're showing large signs of success overall, to the point where other states are starting to get involved in the Raise the Age issue as well. So like I said before, if you're really interested in this topic in Connecticut or anywhere else, go do some research. This might be a perfect final paper thing if you're still struggling with where you want to go next with your final paper. So yeah, it's a really, really good, strong initiative that Connecticut is pushing through, and I hope more states do it too. Next week, what we're going to do is switch gears a little bit, and we're going to still focus on our special offender topics, but we're going to be talking about female offenders, and we're sort of going to tackle the differences that exist between male and female offenders in terms of how they commit their crimes and how their incarceration experiences are different from one another as well. And when we finish with female offenders, then we're going to turn our attention to one of my favorite weeks of the semester, and we're, in terms of population, or incarceration population topics. And we're going to focus on special populations concerning the elderly, sex offenders, and those with mental health issues. So next week, like I said, we'll talk about female offenders. So meet me back here next week when we talk about that. And I hope you all have a great rest of your day. Thank you for your time and attention in this lecture, and I will see you guys next week. Let me know if you have any questions or need help with anything moving forward. Otherwise, you guys have a great day. Thanks. Bye.